Hello, everyone. My name is Andy Biggs from Arizona's 5th Congressional District. Thank you for joining me today. We have a really great guest with us, law professor from Sandra Day O'Connor School at Arizona State University. And this is really important what he's doing. His name is Ilan Wurman. He is an associate professor where he teaches administrative law and constitutional law. He writes on administrative law, separation of powers, and constitutionalism. And his academic writing has appeared or is forthcoming in the Yale Law Journal, the Stanford Law Review, the University of Chicago Law Review, the University of Pennsylvania Law Review, the Duke Law Journal, and the Texas Law Review, among others. And I will just say, as an attorney as well, those are some very impressive journals that you've been published in and that you're going to be published in. So, Professor Wurman, thanks so much for taking time and being with us today.
Thanks for having me.
We're talking today about some of the constitutional implications of lockdown orders, orders given by mayors and governors, and in particular, our own Arizona governor recently. So, Professor, when we start talking about some constitutional issues, some duties legislature just can't delegate to the executive branch. So talk to us about the non-delegation doctrine a little bit and why you're using that doctrine in preparation for your lawsuit against the governor of Arizona.
Yeah, sure. So I'm representing about 64 bars that have been closed down. And it's very important to note that we aren't making federal constitutional law claims. We're making state constitutional law claims. State constitutional law claims involve doctrines, like you just mentioned, the non-delegation doctrine, and I'm sure we'll get into the privileges or immunities doctrine as well, that can apply more broadly to other states and also to the federal government. So our case does have implications for federal constitutional law, but to be clear, we're doing this under state law. And the first doctrine that we're advancing, that I'm advancing on behalf of the bar owners, is what's called the non-delegation doctrine. This is actually sort of like Civics 101. Right? We know that we have a separation of powers, that state legislatures or Congress, as you would know, gets to make the law. The executive executes the law, and then the courts adjudicate cases under existing law. So a corollary of this is the legislature can't just give up its power to the executive. It can't delegate its legislative power to the executive. Now, of course, the legislature delegates authority to governors and executives to do things all the time, but there comes a point when the delegation is so broad and so vague that it effectively delegates the legislative power of the state to the governor. So here in Arizona, the emergency statute under which the governor is purporting to act gives the governor the entire police power of the state in the event of an emergency. What's the police power? It's basically the legislative power to regulate for the health, safety, welfare, and morals of the citizenry. And so what we're basically saying is, look, it can't be true that, as Governor Ducey has said, this case is going on for the foreseeable future, or that the situation is going on for the foreseeable future. The legislature is around. It's able to meet if you only called them into session, right? Whether or not they want to meet, like they're available. The legislature still stands. The roads that lead to it are still operational, right? And the response to the coronavirus involves contested and important policy questions over which reasonable people can disagree. So how can it be, if those things are true, that a single person gets to decide to resolve these important and contested policy questions for everybody for the foreseeable future, right? There's no end in sight. He said that time and time again. So what we're arguing is that the governor's authority, basically, it violates the non-delegation doctrine. The authority that he's purporting to exercise is really legislative power. It should be up to the legislature to make these decisions.
Yeah, and right now you have members of the legislature that do want to be called back into session so they can actually put some constraints or guardrails on the emergency statute authority that they gave to the governor. So I've got a couple questions in that area.
Sure.
When we start talking about emergency powers in this particular statute, but that the Arizona legislature gave to the governor, did they put any guardrails? Did they put any constraints on what defines an emergency? Or do they actually delegate the definition right over to the governor as well?
Yeah, well, so they do have some guardrails, and whether the governor is comporting with them is an open question that we're not trying to litigate in our case, but basically an emergency is any situation. It specifies certain situations like earthquakes, riots, fires, floods, air pollution, by the way, is in there, which is interesting. We can maybe talk a little bit about that. And epidemics that lead to extreme peril to the safety of persons and property. Now, some people might say, well, how does he get to decide whether the coronavirus actually leads to extreme peril? What's extreme peril? What's the risk actually has to be? But we're not litigating that, right? We're not litigating the merits of that. We're happy saying that there's an emergency, but it still can't be the case that the entire police power of the state for the foreseeable future is given to one person when, again, the response to the coronavirus situation involves contested and important policy questions. But in theory, there are I want to be clear about this. In theory, there are guardrails in the statute. For example, if there's a fire, a catastrophic fire, the legislature literally can't meet in time, right? So it's clear what the governor can do. He can cut down some forests. He can maybe order your house, cut down to, if it's in the path of the fire, can provide humanitarian relief, create shelters and things like that. But this is very different, what we have here. The governor has purported to exercise all sorts of authority over all sorts of important and contested policy questions involving, education, what businesses can and can't stay open, whether restaurants can and can't sell alcohol, can you close bars but not gyms, or gyms but not bars, or gyms and bars? I guess so. It's total power. And so even though the statute probably gives the governor sufficient standards in the event of a catastrophic flood or fire or riots when the legislature literally can't meet and the scope of the emergency is pretty narrow, here it's going on for the foreseeable future. The legislature is around and the response involves every policy issue under the sun, right? And whether rents should be paid, whether you can evict people, whether students go to school, right? And that's what makes this different.
Yeah, so I really like where you're getting at, but it seems to me that you've added some things there that I think probably were not specified in the statute. For instance, you said if there's a fire and legislators can't get there, so they can't get there to legislate. If there's a flood, they can't get there to legislate. If in this case, is the virus, is the epidemic so great that legislators can't get there? That seems to be part and parcel to what you're saying about when you can delegate, when something's a delegable duty. So I find that very interesting. And I would say that when you start talking about extreme safety, I can't remember the exact phrase.
Extreme peril to safety.
Extreme peril. Yeah, so there is a definitional problem there, especially in light of the fact that if you're going to expand it, say, air pollution, and you're going to say if there's extreme peril, it seems to me that because you've got some definitional problems as well.
Yeah, I don't disagree with that necessarily. I mean, what is extreme peril? In some cases, it's obvious, where if there's a raging fire or there's a catastrophic earthquake, again, it's sort of obvious. Everyone kind of knows under those circumstances what extreme peril is. I don't think anyone would really doubt the governor's authority there. But the thing about the coronavirus is not only is the response to it, does it involve these contested important questions, but it's contested whether, in fact, the coronavirus triggers the conditions for emergency power, because if it in fact leads to extreme peril of persons, safety of persons and property. And so that term in this instance too, as applied to this particular, epidemic, also arguably, potentially violates the non-delegation doctrine because it's too open-ended and gives the governor too much, choice. I mean, how many...
When you talk about open-endedness there, one of the things that you've said a couple of times is and he's used this, and he has actually said this could go on for the foreseeable future. It seems to me that you're going to be making at some point some kind of an argument based on temporality as well, because if it is as open-ended as he's assuming it to be, and as you're arguing it is, then there's no way to adjudicate when the emergency situation is over, because there's no temporality to it. There's no a time pace to it. So talk about that, if you would.
Yeah, I mean, I think at the end of the day, the question is, how do we know when something violates this non-delegation doctrine? How do we know when the governor or the president is exercising legislative power instead of executive power, right? Because they make rules all the time, they make regulations all the time. And, some conservatives think that all violates the non-delegation doctrine, right? And the entire,
I'll probably be one of those.
fair enough. But obviously, there's a lot that we've sort of accepted that the governors can do and the executive can do, but why not this? And so what we're trying to do in our briefing to the Supreme Court, to the state Supreme Court, is we're trying to remind them what the real ultimate test for the non-delegation doctrine is. And this echoes what some of the conservative justices said in a famous U.S. Supreme Court case a year ago in Gundy v. United States. Maybe it was years ago at this point. The question ultimately is, has the legislative body resolved the important questions, leaving matters of mere detail for the executive to fill up? Now, if it's a truly temporary emergency where it's going to come and go in the next 5 to 10 days, because it's a fire, we know it's going to end sooner or later, or the earthquake, and the fallout from that, you can say that the legislature has resolved the important policy question, and the governor, in responding to such a temporary incident, really is just filling in the details, really resolving this extreme peril to safety of persons and property. But if this is going to go on for 2 years, maybe 5 years, what if we don't have a vaccine, right? Maybe it goes on for 5 years or 10 years. And, how many people, how few people have to die for him to still exercise this authority? We don't really know. So if it goes on for the foreseeable future and involves these wide-ranging and important policy questions, that we think suggests that it's for the legislature to resolve, because the legislature has to resolve the important policy questions. That's ultimately what it's about. Now, is it going to be, hard to know sometimes? Yeah, of course. Of course, there's going to, it's not going to be always clear, whether it's mere detail or, whether it's executive power, legislative power. But there's got to be some lines, and all I have to show in court is that this is on one side of that line. But whatever that line is, this seems so clearly to involve important and contested policy questions for the foreseeable future. Like, what more do you want for a non-delegation challenge?
Right. Well, that'll be interesting to see how that argument goes. You've got another argument that you're talking about too, and that's privilege and immunities, equality and privileges and immunities. And I'm going to let you explain that because what it is basically you're taking people who are similarly situated and you're treating them differently. And that's I can't say it any more simple than that, but I want you to expand on that if you would.
Yeah, no, that's exactly right. So again, this is a state constitutional provision. There is a privileges or immunities clause in the federal constitution in the 14th Amendment that says, right, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This was famously written out of the Constitution, as you probably remember, in the slaughterhouse cases in 1873. So for 150 years, this has basically been totally ineffective at the federal level. But state governments, including Arizona, dozens of states, in their constitutions have similar provisions that basically require equality in the privileges and immunities of citizenship. This means the government can't give special privileges to a privileged few, right? To a privileged 1%. You can't create monopolies, historically, sort of the understanding. The privileges and immunities of citizenship, including the right to earn a living, the right to pursue a lawful calling, right? And to operate in ordinary business and ordinary occupation, right, is a privilege of citizenship, of state citizenship in this case, and the state has to give those privileges equally. So what do we have here? Basically what we're arguing, our first argument is the legislature has to make this choice, right? But even if they make this choice, or the governor makes this choice, they have to treat similarly situated individuals similarly, which means if they think we need to shut down the entire economy or the entire, shut down the entire state, I guess they could do that, but they have to eat the entire political and economic cost of doing so. What they can't do is pick winners and losers. I'm representing bar owners. Why am I representing bar owners? Because they've been shut down. They have Series 6 or Series 7 licenses under the state liquor licensing regime. But you know who's open? Series 3, right, microbreweries. Series 12 restaurants that serve alcohol, they're still open. Series 11 hotel bars. Series of 13 or 14 private clubs are still open. Wineries are still open. Tasting rooms are still open. These Series 18, 19, all of these are still open. And why? It's totally arbitrary. It's totally irrational. If the idea is that alcohol impairs judgment, and so people want social distance if they're impaired, which is what they say in their brief, by the way, it's what the governor says in his brief, well, then that applies wherever alcohol is served, right? What do you think is happening? My clients' customers are all being funneled to these other establishments that are serving alcohol until 2 in the morning. So this is blatant discrimination. Everyone knows that some bars have cramped spaces, just like some restaurants have very cramped spaces and poor ventilations, and some bars have spacious outdoor seating. Like my favorite bar, who's now a client, here in downtown Phoenix, Sazerac. When we went before the recent orders, yeah, totally. Everyone had to wear a mask to go to the bar. Plenty of table seating. The outdoor space was much more spacious than the indoor, right? There's much more space outside, and they're closed down because they're a Series 6. Right? But restaurants that are cramped, can stay open. Why do you think that is? Probably because the Arizona Restaurant Association is extremely powerful. And my clients have almost no political power in the state. Well, that's a classic privileges or immunities violation. That's classic picking winners and losers. And so that's the second argument we're making.
Yeah. And the thing I find intriguing about that is you use the term the governor or the state has to eat the economic and political costs of shutting the entire state down if that's what they're going to do. If they're going to shut one down, they got to shut everybody down, kind of thing. And I think that's right. And it gets to something I wrote down earlier when I was looking over the notes about talking with you. And I make this argument all the time. Effectively, we're getting at something that I think is akin to a taking, an unconstitutional taking. And if you have a taking, guess who has to pay the burden? The government and the level of government that is imposing that taking on essentially the victim of that taking. So here you're talking bars, but we've had churches shut down. We've had dry cleaners shut down. We've had any number of businesses. If you ran a little hobby shop or a furniture store, but you weren't a big player, you got shut down. And I know that there's other folks taking lawsuits on the takings issue, but I think they're directly related. So you want to talk about that for just a second, even though I don't think that's one of your claims, but I mean.
Right. Yeah. So that isn't one of our claims. Right now, we're just seeking injunctive relief, right? Declarative judgment and injunctive relief. We just want the governor to stop, to not extend the orders, to not be able to do this again and repeat this. We want to be able to open up. That's what these bar owners want. Now, is it possible, right, that there would be a non-frivolous, what's called a regulatory takings claim? It's possible, right? The historical understanding of takings, as you know, is the government wants to build a freeway and your house, so they literally demolish your property and they have to pay you just compensation. The problem, of course, with businesses is all businesses operate subject to future legitimate, reasonable regulations from the state. And so a lot of those regulations can diminish the value of the business. Well, you're not entitled to compensation for everything that diminishes the value, but there is a line of jurisprudence in regulatory takings. If it's sort of a total and permanent deprivation of value, then it is a taking. It's called a regulatory taking, for which the government might have to pay you just compensation. But the other problem is, so there's that side, it has to be kind of permanent and total most of the time, right? There are some exceptions to that. But the other side is, if the government can show that the regulation was a reasonable exercise of the police power, right, especially in an emergency, then they don't have to pay just compensation. I've actually never understood why this is the law, by the way. But historically, in the common law, in the 19th century, in the 1800s, when all these doctrines, sort of fully developed in America, right? If they tore down your house to build a freeway, they'd have to pay you. But if there was a fire raging and they destroyed your house to stop the fire from encroaching further, you weren't entitled to just compensation. Why? I actually don't know, why that was the reasoning. But the idea is, well, because the fire, stopping the fire was a reasonable exercise of the police power. So look, if we win this lawsuit, then it's possible we would have a non-frivolous regulatory takings claim. But if we lose this lawsuit, we've got no chance because, all the governor has to come in and say is, this was a reasonable exercise of the police power in an emergency situation, and the burden doesn't always fall equally, right? And so maybe, if we win these arguments, there would be something there, but that's not the point, certainly not now, right? The point is stop the governor from doing this again.
Right. No, and I'm not trying to wander too far down that road, but But one of the things that I think about Arizona state jurisprudence in this field is I think that we've had a long line of cases with bad law, because we have, in my opinion, the best takings constitutional provision in the country. It's incredibly specific and incredibly limited and narrowing. And so I don't understand how we ever got to this point of regulatory takings in the state of Arizona, because the constitutional provision was absolutely so incredibly clear and straightforward, coming out of the populist era of the early teens of the last century. So with that, let's get to where we're talking about. You've got the non-delegation doctrine, you've got privilege and immunities issues, and now you're taken to the state Supreme Court. And tell us about the process and why you ended up there and what you're hoping to accomplish there.
Yeah, so in Arizona, there are these quirky procedures that allow you to petition. It's what are called special actions that allow you to petition directly to an appellate court, including the Supreme Court. So we filed what's called a petition for special action. The Supreme Court has original, but not exclusive, jurisdiction over these kinds of actions where we're seeking to enjoin state officials because they're exceeding lawful authority. So clearly they have original jurisdiction over this matter, but they don't have to take it, right? Their jurisdiction over special actions are discretionary, but we meet all the factors. Right? Public importance is a big factor, whether it involves separation of powers, which obviously it involves a separation of powers, right? It is a factor. Whether this affects numerous cases, as you know, there are dozens of other lawsuits in the superior courts and other courts that are going on. So the people of Arizona need clarity, and they need the clarity now, and we meet all the requirements. And all the Supreme Court would be doing if they declined to exercise jurisdiction is kicking the can down the road, causing lots of more legal uncertainty. And that's what we want, and we want legal certainty. And we don't want the Supreme Court to be afraid, by the way, to take this case. And this is important. We're not saying the governor has no authority, okay, to handle a contagious pandemic or epidemic. There's actually an entire provision of the Arizona statutes that deal, and you know this, with contagious diseases, right? It's Title 36, especially Section 787, right? As opposed to Title 26, Section 303, which is the emergency statute. There's an entire provision dealing with contagious diseases, and the governor has ample authority. The governor has ample authority. He can order people quarantined who have been sick or known to be exposed, right? There are due process protections and so on. The county boards and cities, can take sanitary measures. I don't think closing down businesses is a sanitary measure, by the way. I think social distancing requirements, masks, temperature checks, plexiglass, all of those are sanitary measures. And my clients, by the way, were all investing in, tools to meet those. I had one client who bought a bunch of plexiglass, to separate, tables and so on. Those are sanitary measures. Closing down a business, though, is not a sanitary measure. And in fact, the Arizona statutes only give cities the authority to close down businesses, and only in one circumstance, when it's necessary for the peace and order of the city. I suppose if there are raging riots or something like that. So what we're saying is the governor has ample authority, but he doesn't have unlimited authority. And so we don't want the Supreme Court to be afraid to take this. The Supreme Court won't neuter the governor's ability to respond to this emergency. It'll just mean the governor has to actually follow the statutes that specifically deal with contagious diseases. And we think that's perfectly reasonable.
Yeah, no, that's great. Those are great points. Now, just to kind of, as we get toward the end, I want to just get 2 points in. We've already talked about this. This has implications for, under federal constitutional principles as well. And the slaughterhouse cases notwithstanding, I mean, it really does have some implications on what we see federally application. So I'd like you to talk about that for just a quick sec.
Yeah, so again, we're doing this under state law, but we know that there's a non-delegation doctrine at the federal level. The entire administrative state has become something under siege, somewhat under siege, and we have now, it sounds like 5 justices who are willing to reconsider the existing non-delegation doctrine. The existing non-delegation doctrine at the federal level basically has allowed all sorts of broad delegations, right? The theory is if Congress, as you know, you're in Congress, if you get an intelligible principle, then that's enough. Well, what's intelligible? We want clean air. And EPA, you figure out how to do it. Apparently that's intelligible, as you know. So it's literally only stopped 2, maybe 3 statutory provisions in all of history all in 1935. And since then, with all this expansion of the administrative state, nothing has been struck down. And so, our case has potential to, kind of clarify and elaborate on some of the issues, what the real non-delegation test should be, this important subjects versus filling up the details and so on. And so this might be able to translate to the federal, level too, which is why in our reply brief, we actually cite Justice Gorsuch and the others in their Gundy dissent. As for the privileges or immunities clause, that's a bit harder. At least with non-delegation, at least in theory, there is a non-delegation doctrine, as you know, even though it's under-enforced. The privileges or immunities clause has literally been written out of the Constitution for 150 years. But I am trying to resurrect it. My next book is actually called The Second Founding, An Introduction to the 14th Amendment, and it argues that the privileges or immunities clause was actually intended to be an anti-discrimination provision. And so I'm trying to resurrect this reading. And that's basically what I'm saying that privileges or immunities clause of the state constitution here in Arizona means. And so, look, there are ramifications. There's a spillover to other jurisdictions, including the federal level, which is why I think this is a particularly interesting case on a number of levels.
So last thing, I've got some closing comments when we're done here, but the last thing I think that is so important here is we've been talking about legal doctrine, but for your clients, this isn't just about legal doctrine. This is about economic survival, about families, about mortgaging your home and opening up a business and putting your heart and soul in it, and then having it ripped out of your hands. And so you have economic, you have emotional stress and duress that goes along with it. Talk about the ramifications a little bit for your clients based on the humanity of this thing.
Yeah, I'm actually really glad you asked that, because I want to be very clear about something. None of my clients denies the existence of the coronavirus, or denies that it can be very deadly, or denies that they need to take, sanitary measures and social distancing and things like that. All they're saying, all they're saying is that the response to the coronavirus isn't cost-free. Yes, there's economic devastation, and that's the key for them, right? But by the way, there's also other costs as well, right? I mean, Dr. Carrot Chris has said that suicides are above the baseline for the previous years. Well, I want to know how many? 1,000 over the baseline? 500? Because that's a cost-benefit analysis.
Just so you know, Professor, the number of calls to suicide hotlines in the state is more than double since we've gone to these lockdowns.
Yeah, and so why does no one ever ask Dr. Chris that, in press conferences, which is what's the cost benefit? Like, how many lives are we losing, right? But from the response, right? And so again, it's important just to recognize that no one denies that the coronavirus is here, that it's a threat, that measures need to be taken, but they're not cost-free. There are health costs that no one seems to be talking about. And then there's economic devastation for these particular clients who, again, don't have the political clout of the Arizona Restaurant Association. It's not just that they can go on unemployment insurance. Their employees will have to go on unemployment insurance. They've already had to let go tons and tons of employees, right? But these are small business owners who have two of everything to pay: 2 water bills, electricity bills, 2 mortgages or rents to pay. And if this goes on much longer, they will have to close or risk opening, right? They'll just open up, and if they lose their license, they lose their license. What's the difference if they were going to close their doors forever anyway, because they can't survive anymore? So this has real world impact for many, many, many businesses, small business owners. It's not simply getting a handout from the government. It's their life's work. It's their life's work. It's their businesses that are at stake. And all of them invested in measures to protect against coronavirus spread in their establishments. And all of them should be given an equal opportunity to do so, along with the restaurants and hotels and resort pools and things like that remain open.
Yeah, and you know what? They relied on representations that they would be able to operate their businesses during this virus, and that's why they undertook the risk and the capital expenditures to rehabilitate, if you will, their facilities so they would be in compliance, and then that was ripped away from them. So, I'll just close out by saying there is no activity in life that doesn't come with some risk, and we acknowledge the risk of this COVID and how it spreads, and your clients are willing to basically fight the risk and take it on and try to address it and mitigate it in every way. And those who want to go into those establishments, they are also choosing to accept the risk of going into those establishments. I mean, that is so critical to understand this thing. But Dr. Ilan Wurman from the Senator Day O'Connor Law School at ASU, you have had risk in doing this because I can guarantee you the fact that you're defending bar owners in this, you will draw fire from people you probably already have. You'll draw fire from people who will want to cancel you as a professor, as a scholar, an academic who's publishing. And I would just tell you, it takes some courage to do that. And I appreciate your willingness to do it and fight this fight because, I mean, let me tell you, every time I go on and I start talking about data, I start talking about science, I start talking about law, I start talking about risk, I start talking about accepting certain risks. I hear I hear from a less pleased side of our society. So I thank you for what you do. I wish you the very best in your lawsuit. I hope that you'll come back and keep us posted from time to time, and tell your clients that I'm wishing them well and pulling for them.
Thank you so much. It was nice chatting with you.